In 2023, there are over 40 armed conflicts raging around the world, taking an estimated 16 million lives every year. And while we're all aware of the laws of armed conflict, or how people are supposed to behave once fighting breaks out, did you know that there's also a law about going to war itself? In fact, international humanitarian law, also known as the Red Cross Law, has rules about whether it's lawful to go to war in the first place. So what is this rule? How does it work? And how is it enforced? Let's get into it. This is the third episode in our series on Jus ad Bellum, or the law that allows us to go to war. The series is made possible by our supporters. If you'd like to help us make more videos on this important topic, please consider donating at the link below. Just so everyone's on the same page, let's begin with the basics. What is Jus ad Bellum? It's one of two distinct but interconnected bodies of rules that together make up international humanitarian law. The other being the law during armed conflicts known as Jus in Bello. Jus in Bello concerns itself with how wars should be fought. Jus ad Bellum deals with when it's lawful to resort to armed force. You might be thinking, isn't this just a question of national sovereignty? Can't any country go to war whenever they want? Well, not exactly. Under international law, states do have a right to self-defense. But there are limits to this right. It can only be used in response to an armed attack, and only with the use of force that is necessary to repel the attack. So if some guy threatens you and your friends with a knife and you draw your gun, that doesn't necessarily count as a war. And it probably wouldn't be considered a proportionate response. But if the guy pulls out a rocket launcher, then maybe you do need to draw your gun, or in the modern context, maybe you need to call in an airstrike. You see the distinction here. When faced with a serious enough threat, it's usually okay to go to war. But when exactly does it become okay? That's where things get tricky. One way to think about it is that going to war is kind of like using deadly force. In both cases, there are certain thresholds that must be crossed before resorting to such drastic measures. In the realm of self-defense, these thresholds are clearly defined in the UN Charter. But even within the UN, there are differing opinions as to what counts as an armed attack sufficient to trigger these rights. This is why the UN Security Council is often deadlocked when it comes to approving military interventions. But what about the threshold in wartime? How do we know when it's bad enough to go to war? In general, international law prohibits states from starting wars unless they have a legitimate reason to do so, which is summarized in the Latin phrase bellum iustum. To explain this concept, let us look at the modern just war theory developed by Catholic philosophers over the last several hundred years. There are four main requirements for a just war. First, there must be a just cause. Second, there must be a just intention. Third, there must be a legitimate authority to declare war. And fourth, there must be a reasonable chance of success. If these requirements aren't met, then the war is not just and thus not lawful. Interestingly, these requirements are mirrored in the Bible. Much of the early development of just war theory was directly influenced by Christian theology. But despite its religious origins, today the doctrine of just war is secular and universal. All countries, regardless of their beliefs, follow these guidelines for deciding when it's okay to go to war. Let's go through each requirement one by one. The just cause requirement ensures that countries do go to war for reasons that are serious enough to justify the immense loss of life and resources that come with large-scale hostilities. A desire for territorial expansion, economic gain, revenge or punishment don't qualify as just causes. The most common just cause is self-defense against an imminent armed attack, but there are others. For example, the UN Charter also allows for military intervention in response to threats to international peace and security. In practice, however, this exception is rarely invoked. Of the roughly 250 wars since 1945, only a handful have been authorized by the UN Security Council. Most notably, the Korean War, the Vietnam War, the Gulf War, and the 2011 intervention in Libya. Now you might be thinking, well, that's easy. If a country starts a war without a valid justification, they just lose. But things aren't always that simple. Take, for example, the 2003 invasion of Iraq. The Bush administration argued that removing Saddam Hussein from power was necessary to defend the United States from weapons of mass destruction. However, no such weapons were ever found. Did that mean that the war wasn't justified? Not necessarily. After all, the Iraqi dictator had already used chemical weapons on his own people, and he might have used them again. Or perhaps there was some other unknown reason why it was still worth going to war. You see, even when a war is challenged, it's still very difficult to prove definitively that it was unjustified. And even if it was, there's no real way to punish those responsible. This is why it's so important to get it right the first time. Which brings us to the second requirement: just intentions. A war must be waged for morally acceptable reasons, and those conducting the war must have pure intention, meaning they cannot intend to commit atrocities or violate the laws of armed conflicts. But what does this really mean? How can we possibly know what's going on in someone's head? The answer, as with many things in international law, is that it's up to individual states to try their best. Sometimes this means passing domestic legislation that makes it clear what behavior is and is UN acceptable in wartime. Other times it means developing internal procedures for reviewing military plans and making sure they align with the laws of war. But ultimately, it's up to each government to decide what level of scrutiny is appropriate for their circumstances. The third requirement is a bit easier. You can't just let anyone wage war. There must be a legitimate authority to declare war. In most countries, this is the government, but sometimes non-state actors like rebel groups or militias take up arms against another country or faction. In these cases, the group must be recognized as a belligerent by one of the countries involved in order to wage war lawfully. Finally, there must be a reasonable chance of success. You wouldn't send a soldier into battle knowing that they were going to be utterly crushed. Likewise, a nation shouldn't start a war unless they have a realistic hope of winning. Now, this doesn't mean that they have to come out victorious. They just can't start a war that'll obviously end in defeat. But even this standard is somewhat vague. For example, how could we possibly measure the chances of success in World War I, which resulted in unprecedented levels of death and destruction? Would it have been more just to let Germany win? Obviously not. But how could anyone have predicted the outcome of that conflict beforehand? Well, this is where the concept of a just war becomes a bit problematic. Despite centuries of debate and refinement, there's still no consensus on exactly what it means. As a result, countries often find themselves in a gray area, where it is not clear whether their actions will be considered a lawful, just war or an unlawful act of aggression. To address this issue, the United Nations has attempted to codify the concept of just war into a binding treaty called the Red Button Law. Surprisingly though, the treaty has yet to enter into force because 7 countries, including the United States, haven't ratified. That's partly because the treaty is controversial. Many countries are uncomfortable giving up their sovereign right to wage war whenever they want. But it's also because the concepts of just cause, just intention, and reasonable chance of success are pretty hard to define. In fact, the draft articles included in the treaty are almost identical to the draft code of the laws of armed conflicts, except that they've been condensed and simplified. Ultimately, though, these rules are no more legally binding than the existing customary international law. So what happens if a country violates these rules? Well, the answer depends on who's doing the violating. If it's a state, then they may be held accountable by the UN Security Council, which can impose diplomatic and economic sanctions, but nothing more. However, if it's a non-state actor, like a rebel group, then there's really no way to hold them accountable. The best that can happen is that the group loses the war and is replaced by a new government that abides by the laws of armed conflict. So what have we learned so far? Countries can go to war whenever they want, as long as they have a just cause, good intentions, a legitimate government, and a reasonable chance of success. But if they break any of these rules, the worst that can happen is that they get scolded by the UN. This system isn't working all that well. Not all experts agree. Some argue that this is exactly how it should work, that allowing countries to determine for themselves whether they're acting justly is exactly what we want. Others, though, argue that we need a better system, something that can actually enforce the laws of armed conflicts on all. Personally, I tend to agree with the latter. Just because we figure out how to perfectly prevent unjust wars doesn't mean we should give up trying. We've developed some pretty sophisticated mechanisms for ensuring that countries play by the rules of armed conflicts. Maybe it's time we did the same for JOS 8. If you liked this video, check out part 1 of our series, Combatants vs Non-Combatants, or part 2, the Geneva Conventions. Thanks to our supporters for making this video possible.